So you were a professional assistant for how long?
Um, about 2 years or so.
What then
Three.
happened? What then happened?
That was in the mid-1990s, Chief Justice.
Yes.
I decided to go to the Masters Division in Grahamstown, where I wanted to become familiar with estate work and insolvencies and liquidations.
Yes.
At that point in time, I envisaged that sometime in the future I would probably wanted to have established a
I
practice.
missed out on the latter part.
At that point in time, Chief Justice, I envisaged that I would probably take a direction in practicing in that sphere of work. And I went to the Masters Division to become familiar with that subject matter.
Yes.
And
Maybe before you move on, is our master's office functioning in a way that pleases you, or do you have concerns?
you mean presently, Chief Justice?
I beg your pardon?
Do you mean presently?
Well, are you satisfied with how it functions?
Presently, Chief Justice, I have no contact with the Masters Division because I've been practicing for my own account as an advocate since 2001. I know that it services a very broad section of the Eastern Cape community. There is also an office in Port Elizabeth. I'm not quite sure about the level of service delivery in the division, Chief Justice, so I cannot comment on whether it is functioning adequately or not. I have had contact on one or two isolated occasions with colleagues that I got to know back in the day. They seem to be okay.
Yes. The distance between the rural communities and the nearest point of service, particularly in relation to either in relation to estates and whatever entitlements children might have from their deceased parents and so on. Is the distance reasonably acceptable?
Chief Justice, look, the Eastern Cape is primarily a rural province. I know that people do travel if they need to get to certain areas within the Eastern Cape where they need services. Back in the day when I was at the Masters Division, I was aware that there were members of the public, not only within the Grahamstown community, but in the broad community throughout the Eastern Cape that had to travel to access services from the Masters Division.
Yes.
I'm not quite sure what the situation is right now, Chief Justice.
Yes.
If I were to say anything, I'd be speculating in the extreme.
Sure. And you've been an advocate, a member of the bar for about 18 years now, am I right?
Yes, that is correct, Chief Justice.
And tell us how that long period of practice, coupled with your acting instincts, have equipped you for the position you're now applying for.
Thank you, Chief Justice. 18 years seems like a long time to be in the profession, Chief Justice, but it certainly went by very quickly. Chief Justice, I started acting in 2014, and since then I've been acting fairly regularly over various periods. During 2018, I did not take on any acting positions at all, but effectively from this year, March, I have been acting throughout the year. And it was only recently, I think it was at the end of the third term, being the 22nd of September, that my acting stint had finished.
Did that leave anything left of your practice? That long period of absence? I ask because I know as when I was judge president, it was very difficult to get a busy advocate to act for a month. They would give you weeks, you're lucky if you have them act for a month or longer.
Well, Chief,
and that was because they said, well, what am I going to be going back to?
the consequence, Chief Justice, of having been absent from my practice for such a long period of time is that it has become dormant. Understandably, there is a perception very broadly and widely that I've been unavailable and therefore not in a position to undertake work on a briefing basis.
Yes,
So my practice is dormant as it is at present.
yes. And I take it that you have dealt with a wide spectrum of matters that come before the division in which you serve.
Yes, Chief Justice. The spectrum of exposure that I have is what I've indicated in my papers, more or less in the areas of law that I have indicated. Unfortunately, Grahamstown is not a center where one could get a fair spread of commercial work, for example, that one would otherwise get if one was positioned in a larger center. But what I've been exposed to is what I've indicated in my papers, Chief Justice.
In totality, for how long have you acted as a judge?
Chief Justice, since 2014, I think in the aggregate, probably about 12 or 13 months.
Yes. And what is the average period over which you reserve a judgment, or you would reserve a judgment?
The norms and standards set a limit of 3 months, Chief Justice. My delivery in all the judgments that I've delivered, they've been on time in the sense that they've been within the 3-month period.
Yes.
Some judgments, Chief Justice, are delivered within a matter of a few days, particularly urgent matters, which understandably require urgent delivery and attention,
Yes.
bail appeals and so on. Other judgments, well, more or less within a period of 2 to 3 weeks, but all in the main, Chief Justice, assuredly have been delivered this time round well within the 3-month period.
Yes. JP?
Thank you, CJ. Good afternoon, Council.
Good afternoon, Judge President.
In terms of paragraph 5.2.6 of the norms and standards, judgments in both civil and criminal matters should generally not be reserved without a fixed date for handing down.
Yes.
I'm not going to read the entire paragraph, but it says, save in exceptional cases where it is not possible to do so, every effort shall be made to hand down judgments not later than 3 months after the last hearing. Do you believe that this time frame is reasonable? Do you believe it should be increased or decreased?
Judge President, that depends entirely on how the division is circumstanced in relation to the amount of work in the division. But in my experience thus far, as I've indicated, I have consciously made the endeavor to ensure that my judgments have been delivered within that period. There are challenges in terms of certain time frames, but on a fair conspectus, Judge President, I think it is reasonable. I would imagine that if a judge has difficulty in delivering a judgment within that specific time frame, the difficulty would obviously be brought to your attention. But on a fair conspectus, I think the period is not unreasonable.
Thank you. Second question relates to case flow management. We have a situation where, with effect from 1 July
Yes.
2019, Rules 30 and 37 were amended
Yes.
to give effect to case flow management. Are you of the view that prior to 1 July 2019, the judiciary was precluded from implementing case flow management?
No, there might not have been a formal set of rules in place, but case flow management was implemented progressively in our division, and that produced results. And I would say that the results were geared towards promoting access to justice and efficient delivery of services.
Generally speaking, is it a dispensation that you would uphold?
Yes, certainly one has seen results, definitely.
And during your acting stints, were you at some point given work files to manage?
That's correct.
Then you acted prior to 2017, obviously.
Yes, Chief, Judge President.
But at least I can account for the period spanning October 2017 when I became JP,
Yes.
up to and including 30 September 2019. I'm able to tell this commission that you did 5 weeks of civil trials, 5 weeks of criminal trials, 6 weeks of appeals, and 3 weeks of motion court. Do you believe that this period, together with the previous acting stints, has equipped you to avail yourself
Yes, I do
and
believe
rise
that.
to the occasion?
Yes, I do.
Thank you, CJ.
Thank you, Judge President. Premier?
Thank you, CJ. Once more, good afternoon, Council.
Good afternoon.
CJ, I don't have much. My problems are just across the Kai in that province. I just wanted to get a sense from the advocate, the interest for Grahamstown as against Mthatha. So if I may just get a sense, and last one, so that I don't come back, on conveyancing work, the transfer of bonds, etc. It appears to be a kind of a white-dominated space in terms of what's happening. What do you think should be done in that space? Why our own previously disadvantaged people are unable to crack it?
To get back to your first question regarding my preference for Grahamstown, it's where I live, it's my home. So naturally I have a sentimental attachment. I'm not averse to being appointed in any other division, but Grahamstown in particular is where I live. I am aware that if I'm considered eligible for appointment, as judges in the division, we are circulated to deliver services in various parts of the division. Getting back to the second issue that you raised concerning conveyancing work, yes, it's somewhat difficult for me to comment as an advocate because that is work that advocates do not do. It's set aside primarily for attorneys who have experience and who have a special qualification in that area of expertise. But it is of note that in the Eastern Cape, I've noticed that there are very few historically disadvantaged conveyances. Now, the reasons therefore obviously are historical. But in terms of seeking to redress the situation, I think it would require intervention from various bodies to ensure that there is training that's made available to practitioners who have a particular interest in that area of specialization. And the training should be designed in such a way that it facilitates entry into that branch of practice.
As the advocate, it's not just a matter of training alone. There's an added challenge. I know of conveyancers who are black who say that even if it would be, say, a project by the equivalent of this structure created under the Housing Act, I think it is, that that corporation which built houses in collaboration with the is it Human Settlement Department, and then sell to people. That work doesn't come to them. Work that would ordinarily be used as an empowerment tool for women and black conveyancers who don't have access to the wide spectrum of work there. They don't get it. So some of them have got their admitted notaries, conveyancers, but it means nothing really. That's what they have said to me. What then could be done?
Chief Justice, you know, it requires the will and the commitment of those who have access or who are in a position to ensure that that kind of work is distributed. It certainly requires a will and a commitment, and I'd say a duty on their part to ensure that work of that nature is spread. By parity of reasoning, I would say that it tantamounts to the same thing in terms of briefing. There should be a commitment to ensure that people of historically disadvantaged origin are given the level of exposure that the nature of the work requires, because unless they get such work, they will never be equipped to be in a position to deliver such services.
And for the record, I know there is work that can only be done on behalf of the state by the state attorney. That's not where I am. I'm talking about something else that extends even to the state-owned enterprises conveying work. Honorable Singh.
Thank you very much, Chief Justice. Good afternoon, Advocate Rugunanan.
Good afternoon, Commissioner.
I've got two questions.
Yes.
One is related to what you state on your CV on page 21, Convener Pro Bono Committee, Grahamstown Bar 2005 to date.
Yes.
I'd just like to have a sense of what does it mean being the convener, what is the modus operandi of this committee, and how many people, if any, have you all assisted in terms of pro bono work from 2005 to now?
There is a commitment on behalf of the profession to render pro bono services to indigent litigants. And this is part and parcel of ensuring that they have access to justice and also empowering them insofar as those services are being rendered. My role on that particular committee has been to ensure that if there is a request that pro bono work be done, I put that request before the Bar Council, which the Bar Council considers. The Bar Council then decides who it will be approaching in order to have the work done. So that is essentially my role.
Just as a follow-up to that, Chief Justice, in the last 13 to 14 years, can you remember how many people litigants have been assisted in the last 13 years?
Various, and subject matter variously as well. In my personal capacity, I've certainly assisted a number of litigants. I can speak of numerous occasions when I've rendered pro bono services, not only as an advocate, in terms of having made court appearances, drafted pleadings, rendered advices, and so forth.
Yeah, my second question relates to submission by law bodies, and one of them is NADEL.
Yes.
I think you've read what they've said, and
Yes.
I don't want to repeat what
Yes.
they've said. But they conditionally support your appointment. Can you just speak to some of the issues that they've raised? I don't want to repeat the issues, we have the issues. But can you just speak to some of those issues that they've raised?
Yes, may I take a moment? Commissioner Singh, there was the issue arising from my explanation in regard to a delayed judgment that was dealt with at my previous interview. And Nadel seemed to be of the view that my explanation seemed to suggest that when I returned back to practice, I seemed to have abrogated my duty towards ensuring that the judgment was timelessly delivered and preferred getting my practice back on its feet, as it were. I feel awkward about it, but if that is what came across during the course of that interview, it was certainly not intended to convey that I put my practice commitments far higher than the delivery of that judgment. If you will recall, during the course of that particular interview, I expressed regret at the fact that it took me so long to write that judgment.
And since then, are there any judgments that you've taken extraordinarily long to write?
Not at all. I'm pleased to say that there has not been a repetition of that error.
Just follow up, Chief Justice. There are a couple other issues that they raised there. Your association with Nadal, which I think is a private matter, and then your mentoring of junior practitioners and your transformation. What can you talk about transformation in particular? Thank you.
Insofar as mentoring is concerned, I had a pupil whom I mentored several years ago. At our bar, pupils are allocated pupillage. They're allocated to a specific individual. But what generally happens is that the pupils are rotated throughout the bar so that each pupil has opportunity of doing work with a particular individual. So mentoring is something that is done on an ongoing basis. Insofar as involvement in community projects is concerned, my papers will reflect that I am not a member of any particular community group or organization. But you would have noticed, Commissioner Singh, that I've been a commissioner in the Small Claims Court since 2007, and I also hold an appointment since 2011 for a neighboring district in Somerset East. So to that extent, my contribution stems from the service I render in that specific capacity.
Thank you, Chief Justice.
Thank you, Honorable Singh. Commissioner Sigogo.
CJ, I'm covered by the questions by Honorable Singh.
Thank you, sir. Commissioner Mpofu.
Thank you, CJ. Good afternoon.
Good afternoon, Commissioner.
Yes, hi. Yes, no, I was just one question. It's about the judgment which I think you might have handed down last week. I was in East London last Friday and I saw in the Daily Dispatch that they reported a judgment that you gave about 2.5 million award or so. Remember that one? To an attorney. Did you do that case?
I'm not quite sure of the quantum figure that was reported.
Okay, it was a total, but there was an attorney and a
Yes, there were
municipal
several
manager and a PA
Yes,
and so
exactly,
on and so on.
yes.
All right. But, which, and they quoted extracts, actually have a copy of the paper here, of your judgment, which to me sounded quite well reasoned. But the senior counsel who appeared in the matter, Queen,
Yes.
criticized you in that article for not having taken into account the role of the investigator. What was that about? Can you just briefly say what the case involved and whether that criticism was warranted?
I was unaware that there was media coverage about that particular judgment. That was a civil matter.
It says abusive hawks cost taxpayer 2.5 million.
That was a matter that served before me during the course of this year. It was a claim for damages arising from a series of arrests that were effected against various personnel at the municipality in Lady Grey. What happened is that there was an extremely long and protracted battle against the defendants in the matter. The litigation was fought tooth and nail. And one of the causes of action was that the investigating officer had conducted himself maliciously. And the nature of the malice was such that it would have been a factor, or it was argued that it was a factor to be taken into reckoning when assessing damages. My response to what's been said in the newspaper is simply this, that the fact that something is not mentioned in a judgment does not necessarily mean that it's not been taken cognizance of. When I wrote the judgment, I had carefully analyzed the facts. I was urged to make an extremely high award on the quantum issue in favor of each plaintiff. And I considered all the material that was available to me, and I do believe that the award that I've made was reasonable. I was also guided by precedent in that regard. So what I can say, Commissioner Mpofu, is simply this, that the fact that something is not mentioned in a judgment does not necessarily mean that it's not been taken cognizance of, because no judgment, as you will know, can be all-embracing.
Okay, thank you. Follow up, CJ. So to your knowledge, then, did Queen SC's clients, have they appealed?
I'm not quite sure if there is an intention.
You haven't been approached for
to-
application for
Not
leave
at
to
all.
appeal?
I think they're still well within the time frames, but I have no knowledge about any pending appeal.
Thank you. Thank you, Chief Justice.
Thank you so much, JSC. Commissioner Norman?
Thank you, Chief Justice. Good afternoon, Mr. Rugunanan.
Good afternoon, Commissioner
Thank you.
Norman.
I'm looking at your judgment that appears at page 51.
Which judgment is that?
The one about damages claim against the Road Accident Fund, Pumlan Tsali.
Yes.
Have you found it?
Yes, yes.
Yes, yes, thank you. I'm just, if you were to have a look at paragraph 5.1,
.1.
yes. No, page 52,
Yes,
52. I beg your pardon.
yes,
Are you there?
yes.
Oh, I'm told that the numbering is not necessarily correct on all
it
the
seems-
volumes. But have you found it?
Which paragraph, if you may?
The paragraph it would be paragraph 5.1. That's where all the experts are listed.
Yes, I'm with you.
Yes, thank you. What do you think of parties litigating in these RAF matters, where you will find a string of experts, like you find here? There's about 13 experts, and they want costs for all of those experts. As a judge, how do you look at the necessity? Because you find that sometimes you'll have an educational psychologist, they'll have one from Port Elizabeth, another one from Pietermaritzburg, and they will have various actuaries. How do you as a judge look at all of this and say, in as much as I know that I have to have regard to these experts, but if you are going to give me 13 experts, that's somewhat too much or exorbitant, and therefore I would disregard some of those reports. What is the mechanism that you use? Because I don't think you use that here, because I think you afforded the experts their necessary fees. But I would like to understand, how do you view this? Because this is really costing a lot of money. In fact, most of the funds of the RAF go to these experts.
Yes.
Yes.
Commissioner Norman, it's not unusual in certain cases to see that parties have a string of experts lined up.
Yes.
Naturally, when a matter proceeds to trial, the party calling the expert concerned would obviously have to lead the expert on the kind of expertise that the expert professes to have relevant to a specific issue. If the evidence of the expert is of assistance to the court in resolving the issue, then the costs attendant on the employment of that expert will obviously be granted as prayed for. But there are those situations, Commissioner Norman, where you find that there is a significant overlap in what two experts have to say. And then you are called upon to make a judgment call in terms of whether you're going to be allowing the costs of both experts or one of them. Usually in those circumstances, one would obviously invite submissions from the parties as to which expert's evidence has been more relevant in determining the issue.
Yes. And then, depending on that, then you would disallow some and allow some.
Yes.
Thank you. Thank you, Chief Justice.
Thank you so much. Yes. Well, since we are done, I just want to ask something on this score.
Chief Justice?
Yes, I'll give you a chance now, Premier. A lot of money that should be going to injured people goes elsewhere. Could we not draw lessons from how psychiatric patients are dealt with? In other words, just create a cohort of experts on the assumption that they would be as professional as circumstances require, who would, at government expense, whenever people are injured in road accidents, examine them, determine the nature of the injuries and the kind of treatment that would be required going forward, and recommend to the road accident fund what should be payable, purely on the understanding that any caring government would have in place experts who care about the people of that country, and cut out these huge amounts of money that are being paid to experts under circumstances we don't always understand. How difficult is it to do a thing like that?
Chief Justice, there is some difficulty that I can conceptualize. Usually, Chief Justice, when litigants wish to enlist the services of experts, they make their own choice in regard to whom they will call on their behalf. There is rarely the opportunity that litigants would take between themselves to reach consensus on whether they could be calling one or two experts with a view to resolving an issue.
Let me interrupt you and tell you where I'm coming from.
Yes.
I'm talking about a very deliberate re-engineering of the system. You know there has been abuse, you want to put an end to it. So you come up with a system that is truly designed to assist, but at the same time cutting out these many allegations of corruption even by professionals, so that it becomes easier. As soon as a person is reported injured, the state intervenes. There may even be lawyers, there may even be other experts who are under a hawkish supervision of somebody's eye somewhere within the government setting, just to make sure that you cut out all the shenanigans, and people's matters are quickly processed. The money that is due is paid to the one who's truly injured, rather than that person getting less than the professionals. Isn't it doable if we were to put our minds to it?
Absolutely, Chief Justice. I think a plan such as that could be devised and developed. It sounds impossible, but I think at a practical level, if all interest groups put their heads together, then the sticky issues, as it were, can be ironed out.
I'm reminded, for instance, of the Norwegian system in my interaction with my counterpart there and other colleagues. When a person has a legal challenge of a criminal nature, is a victim of crime, and there is a possibility of suing, already the person is represented by a state-funded lawyer who will make sure that, as part and parcel of the criminal process, whatever damages he or she may have suffered will be looked into. It's one case with two arms, and it's resolved as part and parcel of the same evidence, rather than wasting all sorts of time and energies through technicalities and expecting of people who are poor to find money somewhere or a lawyer somewhere to resolve something that could have been resolved with a little bit of sharper focus to meet them halfway, if not all the way.
I see exactly where you're coming from, Chief Justice. I was unaware of the Norwegian system. But certainly, if that system is looked at and analyzed, one could certainly extract a good few ideas with a view to importing them into this country and devising a workable system.
Yeah, or adapted or improved just to benefit us.
Yes.
I'm sorry if I wasted colleagues' time. Your excuse, sir. Oh, I'm sorry, Premier. I'm sorry.
Thank you very much, Sir. You have helped me a lot. I wanted to make a follow-up on that, but just a last one. What do you think can be done on this issue called medical legal, which is exposing government to billions of litigation, most of the time on the default judgments, etc., etc. What can be your advice? I'm raising this because almost 200 firms have relocated from Johannesburg to establish themselves in Mthatha because Johannesburg has closed the tap, Gauteng working with National. They've closed the tap. Currently, as we speak, the provincial government of Eastern Cape is exposed to almost 25 billion on the litigation of the so-called medical legal. What's your take? What's your view on this?
Medical malpractice, medical negligence, and the suspicion. Premier, just to add so that he answers once and for all, because we discussed it as heads of court. The suspicion that there is collusion between some in the legal profession and some in the medical profession to create these cases, and then even when they are settled, they are often settled, the powers that be are not involved. It's just some scheme between two people. Instead of paying, say, 15 million, it can easily be 150 million because people have agreed to push it that high for the cuts that a number of people must get.
Chief Justice, I've become increasingly aware of reports in the media about collusion between practitioners and expert witnesses in various fields.
You just put it directly in front of you. I think you've removed the yes. You don't need the document anymore.
Yes, thank you. That's much better. As I've said, Chief Justice, I have become aware of reports in the media about collusion between legal practitioners and experts. Whether this is based on fact or exaggeration, I cannot say, but there is a perception out there which has penetrated to a significant extent the public consciousness. From a litigation point of view, all I can say is this, that claims based on causes of action arising in the realm of medical negligence, some of them can be fairly complex, particularly cases such as cerebral palsy, which does necessitate roping in a very wide spectrum of expertise. I've had experience of 2 such cases. These are matters pending. Judge President Mbenenge, you are aware of that. These matters are part heard in Bishu, where I recently acted. I cannot justifiably state, Chief Justice, that in those matters, there has been collusion.
Yes.
All I can do, Chief Justice, in my capacity as a judicial officer, is look at the pleadings, become familiar with the issues, and hear the evidence, hear the arguments, deliver a judgment that speaks of delivering justice.
Yes.
I do believe, Chief Justice, that, if litigation has to be conducted, then professional people and even experts need to be ethical about the way they conduct themselves.
Yes.
And I think it's important to reinforce, not only in the legal profession, but in all professions, that the ethical requirements of acting honorably
Yes.
are of such a high order that they require integrity and honesty. It's difficult, Chief Justice, to police a situation.
Yeah.
And from a judge's point of view, it's all the more difficult to police the situation because you do not want to create the perception that you are not going to be giving both parties a good hearing. You need to maintain independence and impartiality.
Absolutely. I was making a different point, and I think that's the point the Premier was making. That is developing in-house or internal capacity.
Yes.
I had extensive discussions with one of the medical universities in Cuba. And those people have developed incredible capacities at state level. The expertise that causes America to even send their own people to Cuba, although there are diplomatic tensions, to come and land there. The state itself have developed experts in every area. So I'm saying, why can't we do it? If a country that doesn't seem to be at our level economically is able to do it, why can't we start that so that as and when those complicated cases arise, we have state capacity to do it, and the payment can't be the same as that of a private person out there whose tariffs you can't even vouch for. That's all I was saying.
I appreciate that, Chief Justice, and all I can say is that if it's a good idea to build capacity, but we obviously need to do it within available resources.
Sure. And it may well be that those people are charging properly. I'm saying not everybody can afford what is being charged. Why don't you, at least for the benefit of the poor, develop that capacity? Commissioner Fourie, you'll be last.
Chief Justice, perhaps just a remark on what was said. I think from the side of the legal profession, any evidence regarding collusion or anything to that extent which may be untoward, the profession will welcome and the Legal Practice Council will look into, and we invite everybody that hears this to please submit that to us, because we want to see it, and we just don't want as a legal profession to sit and don't comment on it. We will take active steps as far as that is concerned. But unfortunately, with many of these accusations, we need evidence. Please produce the evidence and we'll act.
Thank you. You're excused, Advocate.
Thank you, Chief Justice. Thank you, members of the Commission.